Okay, hi everyone. I hope you are ready for another study session on the law and obligations and contract. So I'm gonna be your virtual companion in studying the nature and effect of obligation, part 1. Okay, we ended our discussion at Article 1162 on the sources of obligations. Now we have here, from the viewpoint of the kind of prestation present in an obligation, it is classified as either real obligation or personal obligation. When we say real obligation, we have here determinate or specific thing. An obligation, a real obligation involves an obligation to give or to deliver. And it can be either a determinate or specific obligation or indeterminate or generic obligation. When we say determinate or specific obligation, this involves an obligation to deliver a determinate or specific thing. So, pag sabihing real obligation, tapos sabihing determinate, meaning the obligation to deliver a determinate or specific thing. But what is a determinate or specific thing? So a thing is said to be specific or determinate, particularly designated or physically segregated others of the same class. So what are the examples of a determinate or specific thing? So let's say, for example, my dog named Bella, or the house at the corner of Aguinaldo Street, ganon. Or Toyota car or BMW with plate number XXX 777, ganon. So, yan ay specific or determinate thing. Now, how about indeterminate or generic obligation? This involves obligation to deliver an indeterminate or generic thing. So, ano naman itong ibig sabihin ng generic or indeterminate thing? So, a thing is generic or indeterminate when it refers only to a class or genus to which it pertains and cannot be pointed out with particularity. So, let's say, for example, a sum of 1,000,000 peso, a cavan of rice, a police dog. So, di ba pag sabihin police dog, sino? Generic siya. It could be a different type of dog. Basta police dog, yun na yun. So, a cavan of rice, di ba? Generic din yun. So, it is very important that we know what kind of thing yung i-deliver in real obligation kasi iba din yung effect ng if there is a loss, deterioration, mga ganon. So, iba yung remedy ng creditor. Depende on what particular thing ba. Okay, parehas. Let's say, for example, for generic obligation, indeterminate or generic obligation, may maxim na janus num pomperit. So, generic thing never perishes. So, pwede siyang, it can be replaced by something for as long as it is in the same genus. Okay? So, now, how about personal obligation? Pag sabihing personal obligation, this involves an obligation to do or not to do. Okay? A personal obligation in turn is either a positive personal obligation, which is an obligation to do, or a negative personal obligation or an obligations not to do. So, familiar now, the real obligation, ito yung parang sa definition ng obligation. Obligation is a juridical necessity to give. So, ito yan, part ng real obligation. Pag sabihin to give, ano ba yung ibibigay? Is it a determinate or indeterminate thing? Tapos, sabi naman ng provision na to do. So, pag sabihin to do, positive personal obligation. Or not to do, which refers to negative personal obligation. So, yan. That's from the viewpoint of the kind of prestation present in an obligation. Now, let's move forward to the nature and effect of obligations, okay? So, we have here, ito muna first, the duties of the debtor. So, ang nature and effect, it lay down the duties of the debtor, the remedies of creditor, ito sa baba, inilagay ko na dito, remedies of creditor, breach of obligation. Okay. Meron din yung delay, yung sa breach of obligation, which will be discussed later. Now, under the duties of debtor, ano ba yung kinakailangan? Kasi nga, di ba, in a particular scenario, we have the debtor, we have the parties of an obligation, we have the debtor and the creditor. Debtor who has the obligation to do it, and the creditor who has may right siya, di ba? We who has the right, and the other person, he who has the duty to do the thing. So, yan, yung mga parties ng obligation. So, sa side ni debtor, what are the duties of the debtor? First, it is laid down in Article 1163, every person obliged to do something is also obliged to take care of it with the proper diligence of a good father of family, unless the law or the stipulation of the parties requires another standard of care. So, ano bang sabi dyan? So, in obligations to give daw, or under the real obligation, the obligor has the incidental duty to take care of the thing due with the diligence of a good father of a family. Pag sabihin natin, diligence of a good father of a family, it pertains to the ordinary care, or that diligence which an average person exercises over his own property. However, sabi ng Article 1163, if the law or the stipulation of the parties provides for another standard of care, said law or stipulation must prevail. So, what could be an example of another standard under the law na sinabi doon ng batas? So, let's say here, for instance, a common carrier is bound to carry the passenger safely as far as human care and foresight can provide, using at most, or extraordinary diligence of very cautious persons with a due regard for all the circumstances. So, in case of accident, the common carrier will be liable if it exercised only ordinary diligence or the diligence of a good father of a family. So, yan. An example of another standard of care, sabi ng batas, under sa common carrier, transportation law. Okay. So, that's for the preservation. Of course, what are the factors that we need to consider? It also depends upon the nature of the obligation and corresponds to the circumstances of the person, of the time, and of the place. It is not necessarily the standard of care one always uses in the protection of his property. General rule, the debtor is not liable if his failure to preserve the thing is not due to his fault or negligence, but to fortuitous events or force majeure, which is under Article 1174. So, yan. First duty ng debtor, preserve the thing. Anong klaseng preservation yung gagawin niya? Is it an ordinary diligence or extraordinary diligence? Remember the factors, the nature, the circumstances of a person, of the time, of the place. So, yan. I-consider yan. Now, what are the other duties of the debtor? Under Article 1164, the creditor has a right to the fruits of the thing from the time the obligation to deliver it arises. However, he shall acquire no real right over it until the same has been delivered to him. So, ano ba ibig sabihin ng fruits? Banana, apple, charot. Iba-iba. So, we have three different kinds of fruits. We have natural fruits, which is being defined as spontaneous products of the soil and the young and other products of animals. So, example nito is trees, plants, on lands produced without the intervention of human labor. Yeah, natural fruit yan. How about industrial fruits? Fruits by lands of any kind through cultivation or labor. So, an example of an industrial fruit is, let's say, rice, vegetables, sugarcane, diba? Products of lands brought about by reason of human labor. So that these are industrial fruits. And the last one is civil fruits, which are those which are derived by virtue of a juridical relation. So examples are rents of building, prices of leases of land and other property, and the amount of perpetual or life annuities or other similar income. So, take note, sabi ng Article 1164, no? The creditor is entitled to the fruits of the thing to be delivered from the time the obligation to make the delivery arises. So, what is the intention of the law? The intention of the law is to protect the interest of the obligee should the obligor commit delay, purposely or otherwise, in the fulfillment of his obligation. Now, meron naman ding tinatawag na personal right at saka real right. Personal right is the right or power of a person to demand from another as a definite passive subject the fulfillment of the latter's obligations to give, to do, or not to do. And the other one is the real right, which refers to the right or interest of a person over a specific thing, which could be ownership, possession, mortgage, without a definite passive subject against whom the right may be personally enforced. Okay, take note that the ownership is acquired by delivery, and ownership and other real rights over property are acquired and transmitted in consequence of certain contracts by tradition. So, yun, the delivery of the fruits of the thing, which is one of the duties of the debtor. So, what are the other duties? What is the first duty? Preserve the thing. Next is to deliver the fruits of the thing. Okay, when obligation, from the time the when the obligation to deliver fruits arises, when from the time of the perfection of the contract. Okay. Now, what else are the duties of the debtor? We have here to deliver its accessions and accessories under Article 1166. So, di ba, napansin nyo, 1163, preserve the thing. 1164, deliver the fruits of the thing. Ang 1165, it pertains to remedies of the creditor in case of real obligation. So, before that, we move to Article 1166, which is the delivery of the accessions and accessories. So, let's define first accessions and accessories. Okay. When you say accessions, these are fruits of the thing or additions to improvements upon thing. So, ano ba ang example nito? We have house or trees on a land. Okay, these are accessions. Rents of a building. Air conditioner in a car. Okay. Addition, take note ha, fruits of a thing or additions to or improvements upon a thing. So what else? Profit, dividend, these are fruits of a thing. Fruits of a thing, diba? Civil fruits. Accessories, what are accessories? These are things joined to or included with the principal thing for the latter's embellishment, better use, or completion. So let's say for example, key of a house. Oo nga naman, paano mo naman gagamitin yung bahay walang susi? Charot. Bracelet of a watch, o diba? Machinery in a factory and a bow or frame of a picture, diba? Note, of course, that while accessions are not necessary to the principal thing, the accessories and the principal thing must go together. Both can exist only in relation to the principal. So, accession is also used in the sense of right, such as the right to the fruits and or accessories of a thing. So, part din ng duties ng debtor yon. So, for example, yung bahay nga, magbebenta ka ng bahay, walang susi, ano yun? Diba? So, you also need to deliver the accessions and accessories. Sabi nga ni Article 1166. Now, let's move to remedies of creditor. Okay. Diba? We already discussed the duties of the debtor. Paano nga naman? Diba? Kung hindi magawa ni debtor yung kinakailangan niyang gawin. So, the law provides remedies on the part of the creditor. So, it is also necessary to know ano bang klaseng obligation that we have. No? Is it a real? Is it personal? Is it does it pertain to specific thing, indeterminate thing, kasi nga iba-iba yung remedies. So, let's start first with the remedies of creditor in terms of an obligation to give. So, under Article 1165, okay, real obligation. So, specific muna tayo. Specific obligation to give a determinate or specific thing. Ayun. So, ano yung mga remedies? First, demand specific performance. Okay? Demand specific performance or fulfillment if it is still possible of the obligation with a right to indemnity for damages. Okay? Or demand rescission or cancellation, of course, in certain cases of the obligation, also with a right to recover damages. Or demand payment of damages only where it is the only feasible remedy. So, in an obligation to deliver a determinate thing, the very thing itself must be delivered. Consequently, only the debtor can comply with the obligation. This is the reason why the creditor is granted the right to compel the debtor to make the delivery. It should be made clear, however, that the law does not mean that the creditor can use force or violence upon the debtor. The creditor must bring the matter to court, and the court will be the one to order the delivery. Okay, so for example, seller sells his piano to buyer for the amount of, sabihin natin, 30,000. Now, if seller refuses to comply with his obligation, okay, to deliver the piano, so the buyer can bring an action for fulfillment or rescission of the obligation with the payment of damages in either case. So, in case of rescission, the parties must return to each other what they have received. So, the rights to demand fulfillment and rescission with damages are alternative, not cumulative. The election of one is a waiver of the right to resort to the other. So, the buyer may bring an action for damages only when if this is not expressly mentioned by Article 1165. Take note, I just want to reiterate that this is the rights to demand fulfillment and rescission with damages are alternative. So, yan is or. Hindi pwedeng cumulative. Okay? Now, under generic thing, pag generic real obligation, on the other hand, it can be performed by third person since the object is expressed only according to its family or genus. It is thus not necessary for the creditor to compel the debtor to make the delivery kasi pwede din naman gawin ng iba, although he may ask for the performance of the obligation. In any case, the creditor has the right to recover damages under Article 1170 in case of breach or violation of the obligation. So now, paano naman if the debtor delays or has promised to deliver the same to separate creditors? So, paragraph 3 gives two instances when a fortuitous event does not exempt the debtor from responsibility. It likewise refers to a determinate thing. Remember, an indeterminate thing cannot be the object of destruction by a fortuitous event because genus non quamperit or genus never perishes. Okay? We will be discussing delay and fortuitous events in Article 1169 and in Article 1174 respectively. Okay? Now, let's move to remedies. Remedies din ng creditor in the case of personal obligation. So, yun nga, may positive, may negative. Ano yung remedy if positive personal obligation? So, if the debtor fails to comply with his obligation to do, the creditor has a right to have the obligation performed by himself, okay, or by another, unless personal considerations are involved. Example, singing, di ba? Yung obligation to do, so maghanap ka ng hindi si Mariah Carey, di ba? Hindi naman yun pwede kasi yung obligation ang for nga ng personal circumstances, singer. So, sabi dito, to have the obligation performed by himself or by another unless personal considerations are involved at the debtor's expense, and in case the obligation is done in contravention of the terms of the same or is poorly done, it may be required that it be undone if it is still possible to undo what was done. So, let's say, for example, nagpagawa ka ng, nagpa-renovate ka ng, nagpagawa ka ng bahay, pero iba yung ginawa niya, hindi bahay warehouse, o diba? In contravention of the terms of the same. or is poorly done. Kung ginawan ka nga ng bahay pero parang sa tingin mo pag gagamitin mo na isang gabi pa lang masisira na siya, o diba, iba din. So, yun. That is the remedies for positive personal obligation. Now, how about the negative? So, that is under Article 1167. Okay. Next is Article 1168 under negative personal obligation. Okay. Dito kasi, sa negative personal obligation, yung obligation mo is not to do anything. Diba? Your duty is to abstain from an act. So here, there is no specific performance. The very obligation is fulfilled in not doing what is forbidden. Hence, in this kind of obligation, the debtor cannot be guilty of delay. So as a rule, take note, the remedy of the obligee is the undoing of the forbidden thing plus damages. However, if it is not possible to undo what was done either physically or legally, or because of the rights acquired by third persons who acted in good faith, or for some other reason, his remedy is an action for damages caused by the debtor's violation of his obligation. So, example, B or the buyer bought a land from seller, and then it was stipulated that the seller would not construct a fence on a certain portion of his land adjoining that sold to B. So, should the seller construct a fence in violation of the agreement, yun na, buyer can bring an action to have the fence removed at the expense of the seller. Kasi nga, yung obligation niya is not to construct a fence there too. Di ba? Hindi, yun na nga. So, wag mong lagyan daw ng fence. Pag ginawa mo na, sige, mag-file ka ng action for the removal of that particular fence at the expense of the seller. So, I think, okay, time check, it's now 11:09. So, we will just cut the topic for the first part on the nature and effect of obligation. If you enjoy, guys, this video, kindly share and subscribe. Okay, and then on the next video, maybe tomorrow, pagsisipagin, we will be discussing the other provisions under nature and effect of obligation. So we will start with the breach of obligation. So we have here delay. We will be discussing. So introduction. So causes of non-performance of obligation. It could be involuntary. So pag sabing involuntary, these are independent of the will of the parties, such as fortuitous event, and force majeure, or it could also be voluntary, those causes which arise from the will of the parties, such as ito na nga, mora or delay, dolo or fraud, negligence or culpa, and the last one is a contravention to the tenor of the obligation, which I'll be discussing it to the next video. Okay, that would be all for this video, guys. Thank you for watching and happy studying. Night.